Hello and welcome. Welcome to everyone that's joining us from all around the world today. It's our day one of the annual ICC Arbitration and ADR conference. And first and foremost, I'd just like to give a big thank you to all of our sponsors that you can see at the top of my screen here. EY, who are our headline sponsor for the next few days. Opus 2, our gold sponsor. Deborah Voice and Plimpton and Wordley Partnership, who are our silver sponsors, and Cura, who are sponsoring our speakers dinner, which is being hosted tomorrow night. And lastly, but not least, Fieldfisher, who unfortunately were due to host our event today in person, but due to train strikes and tube strikes taking place in London today, we had unfortunately no choice but to turn this into a virtual event. I'm sure we're going to be organising something soon at Fieldfisher because they've got some amazing views over the River Thames. So we'll be in touch, don't worry. So now, just for some brief housekeeping, we're just letting people register and join on, and I'll just go through some of this. At any point, please do use the Q&A function on your screen to pose any questions that you might have for our panel and moderators today. Don't wait until the end of the session to make your voice heard. We're keen to hear from you. Please also keep an eye out on the chat, where we will be putting some useful documents that are specifically related to this webinar, and also some links for some useful videos and how to register for other days of the event. This session is being recorded and we will be sending it out on YouTube afterwards. Now, whilst we've been unable to meet in person today, it does mean this session is being broadcast worldwide. And like I say, we have over 260 people joining us from all parts of the world, including Vietnam, China, Brazil, USA, Italy, etc. So thank you for taking part. Tomorrow is day 2 of our annual conference, and that will see 180 people meet in person at EY's offices in London. If you haven't already booked your place, there is still time. So just get onto our website, and my colleague Erica will put the link in the chat room so that you can register for tomorrow. But I would encourage you to do that by sort of in the next hour or so. To mark this momentous occasion of the ICC centenary, we actually also talked to some of our members around the UK, and Erica is putting in the chat some links to the videos, and I do encourage you to watch them if you don't know about the ICC and maybe this is the first event that you're attending. It will give you a really good feel for what we do, why people are getting involved, and how to take part. Moving on to today's session, I'm delighted to introduce our moderators, Samuel Pape, partner at Latham and Watkins, and also representative of the ICC United Kingdom on the ICC Young Arbitration and ADR Forum, and also Sonia Morton, who is Senior Associate in the Dispute Resolution Team at Fieldfisher. Before I hand over to them officially, I just wanted to give an extra big thank you to Sam, who has actually just welcomed a new arrival in his family, a little baby girl. So thank you, Sam, for taking this time out of your probably busy and sleep-deprived diary to do this for us.
Thanks so much, Natalie. It's a pleasure to be here and to have exceptional tranquility, in fact. But no, great to be with you and be with Sonia and to be with Fieldfisher today.
Thank you very much, Sam. So if you're okay, Natalie, I'll kick off. I just want to say good afternoon to everyone. And for those I haven't had the pleasure of meeting, I'm Sonia Morton, a Senior Associate at Fieldfisher in London. And I'd like to offer you all a very warm welcome on behalf of Fieldfisher to the first day of the ICC's annual Arbitration and ADR conference, promoting the rule of law, and this session on behind the scenes of the ICC Court Scrutiny of Draft Awards. As Natalie mentioned, we had planned to host this session in person at our offices in London, but unfortunately, due to the rail strikes and underground strikes, made the difficult decision with the ICC to move it online. We are naturally very disappointed that we won't be able to meet you all in person and welcome you for a drink on our balcony. As Natalie mentioned, we are very lucky to have some lovely Thameside views, but we are also very pleased this seminar can go ahead in person, given that this is a really interesting topic and we have a brilliant panel of speakers for you today. Sam's going to discuss the topic further shortly, but at the very least, I've been able to persuade Sam to join me at Fieldfisher's offices today. We will be taking your questions throughout the seminar, so please be sure to add them to the chat, which Sam and I will be monitoring. And I will now hand over to Sam, who will introduce our session.
Thanks, Sonia. So as you will all know, today's session is about the scrutiny of awards. It's, of course, a key feature of ICC arbitration, which distinguishes ICC arbitration from other types of arbitration. Often it will be, one of the key reasons one would recommend ICC arbitration, perhaps over other institutional arbitration. Yet counsel and users will rarely have an opportunity to witness what it involves firsthand. And so this is a really fantastic and unique opportunity for YAF members, for all other attendees from all over the world now, to gain a behind-the-scenes insight into what the scrutiny process actually involves. And so we're very fortunate to have Colleen Parker from the ICC Secretariat and 3 members of the ICC Court with us today to help demystify the process and run a mock session. And so the way the session is going to be run is as follows. We'll first hear from Krista Lee, KC, after Colleen briefly introduces the ICC Court and the process. We'll hear from Krista Lee, KC, who will be our mock arbitrator for today. She'll give an overview of the rather exceptionally flawed award that she has rendered for the purpose of this exercise. And you will be able to download a copy of that award by clicking on the link that will be shared shortly in the chat. And that award will then be passed over to the Secretariat for scrutiny by it and the ICC Court. And you will have the court holding a mock session at which it will consider the award and discuss it very much in the way that it would do in actual fact. After that, we'll have a Q&A. So as Sonia mentioned, please do pose your questions as we go along, and we will put them to our speakers. It goes without saying, of course, that during the session, everyone will be role-playing, and so the views expressed by Colleen and the ICC Court members may not necessarily reflect their own personal views or those of the ICC. So without further ado, I'll hand over to Colleen, who will kick things off with a brief overview of the ICC Court for the uninitiated and what the scrutiny process involves.
Thank you, and good afternoon, everyone. For those unfamiliar with the ICC, as already mentioned, the court is currently celebrating its centenary, and it is for the purposes of scrutiny. We have the ICC Court and the ICC Secretariat. So the court is comprised of 1 president, who is Claudia Solomon, currently sitting, and 17 vice presidents. There are also 175 court members worldwide who participate in court sessions weekly. This typically includes 2 weekly regular sessions and twice monthly special committees, which address scrutiny of awards that involve dissenting opinions, as well as those awards that involve state or state-owned entities. The regular sessions are comprised of 3 court members, and the special committees have 6 court members in attendance for those decisions. The Secretariat is located in Paris with 7 teams at the headquarters and 5 teams located abroad. These are the case management teams that are responsible for managing all of the ICC court proceedings and include 2 to 3 deputy counsels. Each case is assigned to a deputy counsel who will follow the case from the request for arbitration to the notification of the award, and then 1 counsel who is responsible for scrutiny. So the scrutiny process has 3 layers within the ICC. It begins at the team level with the counsel, and then goes up to the Office of the Secretary General, the management of the ICC Secretariat, who does a further review of an award. Finally, after these 2 steps, the award is submitted to the court for additional comments and review. So as already stated, scrutiny is one of the most distinguishing features of ICC arbitration, and it's one of the greatest value added of using arbitration under the ICC rules. It serves to maximize the legal effectiveness of an award by identifying defects and potential vulnerabilities that might be used to set aside an award at the place of arbitration or resist its enforcement elsewhere. Scrutiny not only therefore improves the general accuracy, quality, and persuasiveness of an award, but also its enforceability. There are several rules that are related to the scrutiny of an award and the requirements of an award rendered under the ICC rules. Notably, Article 32.1 requires that all awards state the reasons upon which decisions are made. Appendix 2, Article 7 also allows the court to consider the requisite mandatory rules at the place of arbitration. And finally, Article 42 requires arbitral tribunals to ensure the enforceability of an award. I would be remiss not to mention on the centenary occasion that these rules are quite a departure from the original scrutiny process when the court was initially created. At that time, scrutiny was limited to procedural and technical formalities. Any of the substance or merits of an award was beyond the purview of the court, which is quite distinct from the rules today, as noted. Although the court is not there to provide a second guessing of a tribunal's decision or to otherwise question the outcome of a particular case, the court is primarily concerned with ensuring that the awards are reasoned, that it's clear in the analysis, that all issues that were included in the terms of reference have been thoroughly addressed, and that any particular formalities at the place of arbitration are accounted for. For example, if in a particular jurisdiction, signatures are required by the arbitral tribunal on each page. These are the types of things that the court will consider when reviewing an award and will make comments to an arbitral tribunal to ensure that the award will be well reasoned, will be in compliance with mandatory laws, and will be enforceable. So there are typically considerations in addition to those that include jurisdiction, interest and cost, the dispositive section, whether the award has addressed all issues of due process, for example, by keeping track of whether or not a respondent has been fully informed of all submissions when they're not participating, and if there's any local rules of practice. We also pay particular attention to the numbers that are cited when awarding certain amounts so that we ensure that the numbers are consistent throughout and are reflected in the dispositive. Finally, we use a checklist that you'll see later on in this presentation that makes sure that these major points of enforceability and reasoning are addressed by the tribunal. The tribunal is provided with this checklist from the beginning of the proceedings, so they are aware of what's required of them and what to keep in mind for the drafting of the scrutiny process, which you will see later as the panel addresses the very flawed award as it's been described.
Thank you, Colleen. And before we proceed to our mock scrutiny session, I would just like to introduce the speakers who will be leading that session. So first of all, I would like to introduce Krista Lee Casey of Keating Chambers, who is going to be acting as the sole arbitrator in our mock scrutiny known as Jafar. And I hope you will all appreciate the Disney theme we have going on. Krista is an experienced counsel who specialises in engineering, construction and energy disputes and has experience of international and domestic arbitration under a variety of rules. And Krista is a fellow of the Chartered Institute of Arbitrators and Chartered Arbitrator and is regularly appointed by the ICC and the LCIA. So welcome very much to Jafar. And if we can now, we are also very fortunate that we have 3 members of the ICC court joining us today to give us their behind the scenes perspective. So first of all, I would like to introduce Christopher Harris Casey, who of 3VB, and he is a UK member of the court. And Christopher is an experienced advocate specialising in complex commercial disputes under English and international law across a range of industry sectors for the courts and arbitral tribunals in England and internationally. And Christopher is also recommended as a leading arbitrator and has been appointed in over 40 cases in disputes under a variety of rules, including the ICC. Krista is ranked in the who's who of global international arbitration practitioners, and in 2020 was designated by the British government to the ICSID panel of arbitrators, and 2021 as the UK member of the ICC court. So welcome very much to Christopher. Second, I would like to introduce Louise Reilly BL, a barrister and Irish member of the court. Louise Reilly is a barrister who specialises in sports law and international arbitration. and holds a number of positions, including as an independent director and vice president of Cycling Ireland, a member of the Bar of Ireland Voluntary Assistance Pro Bono Scheme, and a committee member of the Climate Bar Association. And Louise also acts as an arbitrator in addition to her role as the Irish member of the court. She is a member of the ICSID panel of arbitrators, nominated by the European Commission to the pool of arbitrators for bilateral disputes under trade agreements with third countries, and is a member of the panel of arbitrators and mediators of Sport Resolutions UK. Welcome to Louise. And last but not least, I would like to welcome Fieldfisher's own Paralika, a partner in our international arbitration group, leading Paris office practice and Greek member of the court. Reilly acts as counsel in international arbitration proceedings governed by ICC, ICSID, LCIA, SCC arbitration rules, as well as ad hoc proceedings. And Reilly specialises in construction, engineering, energy and infrastructure sector disputes, both in commercial arbitrations and investor state disputes. And we've had the pleasure of working on a number of projects together. Reilly has appeared in the list of future leaders in the Who's Who Legal Arbitration Guide since 2017 and submitted to the Athens and Paris Bar. So welcome to Reilly and welcome to all of our court members. And I will now hand over to Krista, who's going to talk us through the draft award.
Good afternoon, everyone. So I am today Arbitrator Jafar, and here is, I'm just going to present very quickly the arbitration and the facts behind it. I'm terribly sorry, but I'm able to share my screen, but I can't get rid of the chat. So we'll just have to work around that. So the case is Agrabah Hotels and Jasmine Interiors. And it's a construction dispute, and the project is a luxury hotel based in Agrabah. The employer is the claimant, Agrabah Hotels. It's a company in Agrabah. And the design and build contractor, the respondent, is Jasmine Interiors, and they're based in the Kingdom of Shahrabad. It's a design and build contract. The contractual period for the works was set to be the 1st of January 2020 to the 31st of July 2020. In fact, completion was massively delayed. It was late by a whole year. So the claim brought by Agrabah Hotels is for liquidated damages for delay at a rate of 10 million per month. And the main issue is Jasmine's Interiors entitlement to an extension of time. In their defense, they say that the completion should be extended to the 31st of July 2021, and they rely on various relevant events, instructed variations, late payment, late supply of materials by Agrabah Hotels. The procedural background for this arbitration: the request was sent to the ICC on the 1st of January. The terms of reference were agreed on the 5th of March 2023. Today is not about terms of reference, but terms of reference are a specific ICC document that are unique to the ICC that set out the scope of arbitration. A procedural timetable was set by me in agreement with the parties. We agreed to have memorials, and they were served on time in April and May 2023, so that we had a 5-day oral hearing on the 1st of June 2023. There were then post-hearing briefs. We had one round of those. We had one round of cost submissions on 15th of June, and then very efficiently, I closed the proceedings on the 16th of June, and I've now got my draft award ready, and it's dated so the 30th September 2023. Now, you should all be able to access the draft award in a Word version. I think it's come up in the chat, but I'm going to take you through a few bits of it. Just to read through it, I think, in brief, before we get on to the next session. So I've set out my introduction. I've set out what the dispute is about. It's being administered by the ICC, and I've set out the contract there. It's between A Hotels and Jasmine Interiors. I've set out in the next section who the tribunal is, that I, Jafar, was nominated as sole arbitrator, and I was jointly nominated by the parties, and the ICC court confirmed my appointment. Now, there's no dispute in these proceedings as to jurisdiction. No one's raised any jurisdiction issue, so I've just briefly set out there that the subcontract contained an arbitration agreement, and there was no challenge. It's also worth, I thought, noting under this section that English law applies and the seat of the arbitration is London. I then briefly went through the summary of the procedural background. Again, I don't see this being at all contentious, so I've done that very briefly. I've set out what statements of case were served and submitted, and that there was a final evidentiary hearing. Now, it's always important to set out the issues, so I've done that very briefly. In fact, these were agreed at the time of the terms of reference. What was the cause of delay? Are Jasmine Interiors entitled to extension of time? How, if they are due, what's the correct calculation for liquidated damages? Is there any interest due? And who will pay the cost of the arbitration? Now, in respect to the cause of delay, there was extensive evidence. We had extensive experts. They both produced very lengthy, detailed reports that went on for hundreds of pages. And they said that this was in accordance with the Society of Construction Law's protocol on delay and disruption. Anyway, I rejected both expert analyses. They were both incomprehensible and overcomplicated. And it was quite obvious. We all know from January 2020, we had COVID-19. That's what delayed the project. Moving on, entitlement to an extension of time. Now, because both of these delay experts didn't consider COVID at all, when Jasmine put forward their response, they didn't put forward any claim that they were entitled to an extension of time on the basis of COVID. So that wasn't pleaded. So their whole extension of time claim failed. I calculated liquidated damages then for the whole year, 10 million per month, total for the year, $100 million. Interest was claimed just on the basis, as is usual, in London and England, for such period and at such rate as I should think fit. Jasmine objected a bit to this, but I've obviously found that liquidated damages were due, and so I think it follows that interest should also be due under Section 49 of the UK Arbitration Act. Finally, just to quickly go over costs, both parties wanted costs. Agrabah Hotels relied on Section 61 of the Arbitration Act. Jasmine Interiors relied upon a term in the arbitration agreement that said no party shall be entitled to claim costs. And that's what I found has applied. And so I make no order as to costs. And just briefly, here's my award at the end. Jasmine Interiors shall pay Agrabah $120 million forthwith. And Jasmine Interiors shall pay interest on that. I've compounded it. I've said 2% above LIBOR. And then finally, no awards on costs. And obviously, once the ICC Secretariat approve it, I'll then sign and date it. So there's my award. And I'm sending it off now to the ICC for scrutiny, though I expect there won't be many comments. It's a very efficiently drafted award.
Upon receiving the draft award from the sole arbitrator, we would invite her to complete a statement of time and expenses so that we are able to have an idea of how much work went into this draft award and what expenses may need to be accounted for. If this is a partial award, it will help us keep a financial view going forward. And if it's a final award that's approved, we will be fixing costs at the same time as approving the award. And so any future expenses, for example, sending the hard copies to the parties, will need to be accounted for. We will also inform the parties that we have received the draft so that they are aware at this point that the draft award is no longer with the sole arbitrator, but has now come to the Secretariat and will be subject to scrutiny. A recent change is that we are now trying to give parties an indication of the timeline upon which we will be submitting the draft to scrutiny, although we've always had the same standard that typically drafts are submitted to scrutiny within 3 to 4 weeks from receipt for normal court sessions. For special committees, that's 4 to 5 weeks, just given the fact that we have those special committees less regularly than the weekly regular sessions. And finally, for EPP awards, because of the expedited nature, those are supposed to be submitted to a one member of the court within 2 to 3 weeks of receipt. As soon as the Secretariat has received the agenda, we begin this first level of scrutiny, as I mentioned, and we also do that by preparing an agenda for the court members and completing a checklist. So the checklist and agenda examples should be available for you to consult in the chat, so you can get an idea of the process by which the case and the award itself are presented to the court. If you take a look at the agenda, you can see that it is labeled as a final award agenda. It outlines who the parties are. On the first page, you can see a number of letters that indicate the date on which the request was received, when it was notified, the date of the constitution of the tribunal, when it was transmitted to the tribunal, terms of reference, and final award. This is how we keep track of the progression of the case. We also include information about the parties, and then for purposes of award, we also keep track of the rapidity. So we'll look at when the last substantive submission was and when the draft award was submitted in order to consider how quickly and efficiently the tribunal has been. Finally, there's a section on the summary of the award. So as you can see, we've provided a brief summary of the award, and then also the Secretariat's evaluation, where we present the comments to the court, which the court members will then be able to provide additional comments for at the actual court session.
And if we could now hand over to Reilly, who's going to discuss briefly the court members' role in the scrutiny process. Reilly, you might be on mute.
No, she's taken herself off mute, but for some reason the sound.
Yeah, I'm not on mute.
There you are.
Oh, okay. All right, great. So thank you, Sonia. So what happens after the Secretariat has completed this two-level review of the draft award and has prepared the agenda for the ICC court, then it's time for the draft award with the agenda to be sent to the ICC court members who will participate at the next available session. As Colleen mentioned earlier, the court meets in weekly committee sessions, and it also meets in special committees that take place not as regularly, not weekly. In the past, it was once per month. Now it's more regular. So in the case when an award will be submitted to a committee on one of the weekly sessions, the court members that have been assigned to participate in that session will receive the award about a week before the committee session, together with the agenda. So in practice, the court members will have about a week to review all the documents, review the award, review the agenda. And actually, I should mention that there are several awards that are submitted at any given committee session, together with some other decisions that the court needs to take. So the volume is quite substantial, sometimes, of the documents to review. Personally, I think it takes, to give you an idea of the volume, it would take on average between 1 or 2 working days, depending on the size of the awards and the number of awards that committee members will have to, court members will have to review. So the documents are uploaded on a SharePoint platform, so it's a very useful tool. Court members can access the draft award, they can review the markup already done by the Secretariat, and they can add their own comments and their own corrections or changes on the document. So a week later, as I said, the court session will take place with 3 members. It will be presided by one of the vice presidents of the court, and there will be 2 other court members. During the court session, when it starts, to give you an idea of how the session takes place, the vice president will first invite the counsel in charge of who's leading the team that has reviewed the award. to add any comments, if there are any comments to add. For example, the time spent by the arbitrator has come in late, so the council may want to update the court on this, or anything else that has happened on the file since the court members received the award. And from then on, the 3 court members who have already reviewed and marked up or prepared their comments on the award will discuss, will set out their own individual additional comments, or may have comments on the ones made by the Secretariat in the agenda. These comments, Colleen mentioned, they go to the form, but sometimes there can be comments that are common sense comments, something that does not make sense, something that needs to be explained more, references obviously to evidence, reasoning, etc. So depending on the quality of the award, this discussion may take from 5-10 minutes up to more than half an hour or an hour, especially if the issues are complicated, if the award is long, if, for example, the award has not been approved previously, so this is the second time that it comes to the court for review, then it may take longer to actually go back and forth and see what has been, how the award has been revised and whether it can be approved. So once this discussion is complete, then the 3 members of the court have to take to decide whether to approve the award, whether the award is not in a good shape to be approved. So the decision would be not to approve the award. And the third option is to approve, subject to a certain amount of comments made by the court, and are also included in the Secretariat's agenda. If the award is approved, then there will be a short discussion about fixing the fees of the arbitrator, the arbitrators, based also on the proposal that the Secretariat has made in the agenda. So this is, in a nutshell, how the work of the court from the moment the draft award is sent for review until the actual decision. But maybe Chris or Louise, you may have something to add, or I don't know, just any comments?
No, not for me. Thank you, Marty. I think you covered it all very succinctly and comprehensively there.
Okay. In that case, Sonia and Sam, shall we move to the mock court session to discuss the award issued by the sole arbitrator, Jafar?
Yes, please. Thank you very much, Reilly. I think we can hand over to Colleen to open the mock court session.
Thank you. The Secretariat doesn't have any additional updates to provide the court. Just one comment we would make is that because we are recommending that this award is not approved, we have not provided a financial table fixing costs, but it is worth considering that the award was submitted late, given that the last substantive submission was the oral closing on 8 June, and the award was submitted on the 30th of September, whereas normally we would have expected it by the 8th of August to be within the 2-month deadline. So just something to keep in mind, that this award is late. So in the future, it may be worth applying a reduction on this basis.
Thank you, Colleen. And for the purposes of this mock court session, I will play the role of one of the vice presidents of the court. So I will welcome my colleagues, Chris and Louise, to today's court session. And since there are no more comments by the Secretariat, I will turn to my colleagues to ask for your comments on the draft award. Louise, would you like to go first?
Certainly. Thank you, Marley. And thank you to Colleen and her team for preparing the agenda, which I found very helpful. I agree with the agenda and with the comments set out there by the Secretariat at points 1 to 4. I have some additional comments in relation to points 2 and 4, and also supplemental comments to that. So in relation to point 2, this refers to the expert evidence, and it's set out at page 7 or paragraph 17 of the draft award. I have to say I found the language a little bit surprising, if not shocking. You know, I reject both expert analysis. They're both incomprehensible and overcomplicated. Particularly in light of paragraph 16, where we hear that the expert provided extensive and complex analysis. And I think in circumstances where a 5-day hearing was heard, surely that would have been the opportunity for the sole arbitrator to ask questions to demystify the expert evidence if that was necessary. So I'd be inclined to go back and ask the sole arbitrator, in addition to provide additional analysis of the evidence, maybe just explain a little bit to what extent the expert evidence was tested at the hearing, to what extent she asked questions to try to get to the bottom of what the analysis was, and to give more reasons as to why she rejects both expert analysis. I think the parties would fairly expect more reasoning on that basis. I'm a little bit concerned by the fact that she seems to have decided unilaterally that really COVID was the cause of the delay. And again, I think just explore that with her, where that came from. Was it even mentioned during the hearing? Did she put it to the parties? And again, having read the expert analysis and sitting through the hearing, if it became evident to her that really COVID was the issue here, maybe just explore with her whether that was ever put to the parties, whether they ever had a chance to express their views on that point. In relation to point 4 of the agenda there, and this is in relation to paragraph 22 of the draft award, this is the point on interest, in addition to the Secretariat's comment, with which I agree. I think that LIBOR was discontinued at the end of 2021, that it was replaced by Sonia, by the Sterling Overnight Index Average. So maybe again, just explore with the sole arbitrator, did the parties specifically agree to use LIBOR? Otherwise, I believe the proper measurement should be Sonia. Just a couple of additional comments before I hand over to Christopher. The sole arbitrator is CEO of Agrabah Spas, and I note that the claimant is Agrabah Hotels. Just to double check, is there any link between the two? And if so, was that fact ever disclosed to the parties? Were they given an opportunity to comment or ask questions on that, to just to make sure there's no conflict between the claimant and the arbitrator? And clearly it's a very late stage to be dealing with that issue, but just to make sure that if there is any link between the two, that was fully disclosed at the appropriate time. In relation to, did I have one final point? Yes, is in relation to the costs decision of the arbitrator, and at paragraph 24 and 25, she refers to section 61 of the UK Arbitration Act, which gives the tribunal discretion to award costs. In this case, the arbitration agreement stated that the party no party shall be entitled to claim the cost of any arbitration. I just wonder to what extent the parties pleaded or the arbitrator considered section 60 of the UK Arbitration Act, which provides that an agreement on costs is only effective if entered into after the dispute has arisen. So again, this may be something that has been pleaded and decided and discussed, but just to draw the arbitrator's attention to section 60 of the UK Arbitration Act to make sure that that has been considered. So thank you, Marley. Those are my comments.
Could I just ask for a point of clarification? On paragraph 17, you mentioned, we'll add the comment about the extent of expert witness. Did you also want us to make a comment about the moderating tone, or potentially?
I think so. I think so. Yes. I mean, I would hope that with the supplication of the analysis and the submissions, but yes, if the language, particularly of the first and second sentence, could be modified and perhaps made more diplomatic. And again, I leave that to your skill, Colleen, of how to communicate that, but I think that will be advisable, yes.
Okay. Thank you.
Thank you, Louise. I agree with your comments, and I think these are important points to bring to the arbitrator's attention. Christopher, would you have any additional comments?
Well, I'd start off by saying that I agree with all of Louise's comments and also with the Secretariat's comments. And I'm grateful, as usual, for the very helpful agenda that the Secretariat's prepared for this case. I would like to kick off with a few fairly prosaic points in terms of the start of the award. The arbitrator, and these are matters which are picked up to an extent in the checklist which the Secretariat circulated. I think the sole arbitrator should be invited to consider setting out details of the parties and their representatives, which isn't currently included. The arbitration agreement itself, which is referred to but not quoted, I think for the purposes of enforcement, it would be very helpful to have that in there. It might be helpful to have a little more detail on the procedural history. There are different approaches to that, but this is at the minimal end of the scale. Dates of submission of statements of case and that sort of thing, and any further issues that arose would be helpful. There is also no record of what evidence there was before the tribunal, in general terms, before the sole arbitrator, in terms of, I mean, we hear that there was expert evidence, but it's not completely clear from whom, on what particular topic. Was there any other evidence, witness evidence? Presumably at a 5-day hearing, there was rather more evidence than that. One would expect to see that set out. So it might be that we invite the sole arbitrator to consider expanding those sections somewhat. And then the other matter that occurred to me was while the cost section has the issue that Louise raises in relation to section 60, there's also no reference to the ICC rules provisions on costs and the powers and obligations of the arbitrator in that regard, and in particular to the costs of the ICC and of the tribunal, which have to be recorded in the award, even if no other order as to costs is going to be made, and will need also to be put into the dispositif. And I noted also that the dispositif doesn't contain any reference to the place of arbitration. Again, I think that's been picked up in the checklist, but obviously that's of absolutely critical importance. So those are my additional comments for what it's worth.
Thank you very much, Christopher. And I also agree with the comments that you raise. More generally, I think that this is a bad example of a draft award that should be submitted for scrutiny. There are quite a few issues, important matters that are not satisfactory in this draft award. I will add a few comments and a few points to communicate if you agree to the sole arbitrator. A couple of points of form. In paragraph 3, the sole arbitrator refers to the contract, but in paragraph 6, there's a reference to a subcontract. So it could be a typo, but it's good to check exactly what the issue is here. Then I also noticed that on paragraph 9, the sole arbitrator refers to the dates of the 5th of March as the date when the terms of reference were agreed and submitted, just to clarify that it's indeed the dates on the terms of reference, that the terms of reference were signed by the parties. A typo that I saw in paragraph 10 with the date, the 15th of February, 2023, it should be. And then one more just point to double check maybe with the sole arbitrator on paragraph 11. The hearing apparently took place over 5 days, but it looks like oral closing submissions took place on the 8th of June. So was that after the hearing was concluded, or is there a typo here on with the dates, just to double check with the with the sole arbitrator. I think that would be useful for consistency. And now on more substantial comments, I obviously agree entirely with Louise's and Christopher's comments on the reasoning, and especially the cause of delay, which has not been explained or justified or reasoned. I just wanted to raise one more point on paragraph 18. On the last sentence, the sole arbitrator refers to other alleged causes of delay. And so this, of course, indicates that other causes of delay were put forward by the claimant, and it would be useful to set out here both parties, a summary of both parties' positions on this other causes of delay. But of course, the sole arbitrator will have to look into this again, and this is an additional point, but obviously it will flow from her decision as to how to justify and reason on the decision of the cause of the delay. But more generally, the parties' positions on the cause of delay, on the extension of time, should be set out briefly here. Yes, on interest, and I don't think that this was picked up by Louise. I was wondering, it's the issue about simple or compound interest. On paragraph 21, it's indicated that the claimant claimed interest on liquidated damages without any, without specifying whether a claimant requested simple or compound interest. But in the operative part of the dispositif, the sole arbitrator awards compound interest. So it would be good to clarify that earlier in the award. Yes, last point regarding the costs. The sole arbitrator noted in paragraph 27 that the parties did not have the opportunity to respond to each other's submission on costs. And because she closed the proceedings the day after the submission on costs were filed, it was not possible to invite the parties to make additional submissions. I was wondering if you could raise this issue with the sole arbitrator and see whether she considers that responsive submissions are necessary. And if indeed they are necessary, because, I don't know, maybe it may be necessary to reopen the proceedings for this. But again, it's a matter of determining, I think, if it's necessary. If she hadn't indicated that she was unable to invite the parties, I wouldn't have thought about it. But it would be good to double check, I think. This would be all my comments. So, and of course, I should say I agree with the comments raised by the Secretariat in the agenda. So if my colleagues agree, maybe, Colleen, you could then take all these comments, incorporate all our comments with the Secretariat's comments and communicate them to the sole arbitrator.
Yes, I've taken note of all of your comments, so I'll add those to the agenda and those will be communicated to the sole arbitrator. We'll also make note of some of the typographical errors that you identified, so that we'll send a markup draft so that she'll also be able to consider those typos at the same time.
Great, thank you very much, Colleen. So we need to decide whether we will approve the award subject to the comments made by the court and the Secretariat, or whether we think that the award is not in a good shape to be approved. So I'll turn to Louise and Christopher for your views, and I will express mine afterwards.
Thank you, Marley. I suppose the question always is the Secretariat's interaction and the level of cooperation between the Secretariat and the arbitrator. And if you think she'd be receptive to these comments and would make the amendments as the court suggests. I feel, though, in this case, it goes a bit beyond that the issues raised really are fundamental to the award. I think some of the issues that need to be amended go to the heart of the award, and I think risk undermining the enforceability of the award if they weren't properly incorporated. So I would feel more comfortable having the decision today decides not to approve, so that another court session, another committee then would look at the revised award.
Yes, I fully agree. It seems to me this award is so far from the finished product that we could endorse that it really would benefit from coming back to the court for approval in future, and not just to be let go. And we hope that the comments are implemented.
Thank you both, and I agree with you for all the reasons that you mentioned. I think this award should benefit from another review from the Secretariat and the court before it can be approved. And I do hope, Colleen, that the sole arbitrator will be cooperative and will be able to, will be happy to address and take into consideration, the comments. So I guess that the decision on costs will have to wait until the award comes back and it's approved. And my only question is for Colleen, whether you would want us three to reconvene to review the award, the revised draft of the award when you receive it from the sole arbitrator.
Yes, just to address Louise's question, I do think that based on the experience thus far, that the sole arbitrator has been quite responsive and cooperative in our interactions. So hopefully she'll take these on board and incorporate them. But yes, I would ask that if you guys would be available to receive the award for the subsequent review of the revised award, we would like to be able to resubmit that to you, given that you've already had the perspective of this originally the original award. So I will be in touch with you all as soon as we receive the revised award, incorporating your comments.
Great, thank you.
Very good.
Thank you very much. Sorry, please go ahead. Yeah, I was just going to thank you all. I think everyone was thanking everyone for that very productive session. I think we can now move on to the Q&A, and to kick that off, maybe just a question for Arbitrator Jafar, who has a bit of work to do now. Now with your Krista VKC hat on, I guess from an arbitrator's perspective, can you tell us a bit about your experience dealing with the scrutiny process? Has it been helpful in allowing you to finesse your awards? Can you tell us a bit about that, please?
So, I mean, this is very much a caricature of a bad award, but my experience is that the Secretariat are actually really helpful. When you spent so long drafting an award, which will generally be longer than the 5 pages we have here, it's immensely helpful to have someone check typos, abbreviations, dates. And I mean, although, like I say, this is very simple, sometimes with long lists of issues, like you've got 20 or more issues in an arbitration, it's good to have someone to say, actually, you missed this issue, even though it's really small. The other thing that I find very helpful, or have found helpful in the past, is with the dispositive. It's very important that that's right, obviously, for the purposes of enforcement. And the ICC have a tremendous bank of just standard phrases that will help make sure your dispositive is absolutely cast iron and it covers all the issues. In this particular award, I'd missed section 60 of the Arbitration Act for England and Wales. And but was probably quite a big mistake. But often, or you can find yourself doing an arbitration located at a seat where you don't actually know the local procedural law. And there the ICC will help you out on small things. So for instance, there are some jurisdictions where you have to not only write the date of the award or the date of hearings, you have to write the date of issuance. And so they will give you a bit of a nudge and say, in this jurisdiction, you've got to write the date of issuance. Or for instance, some jurisdictions, you have to sign every single page. With reasoning as well, sometimes obviously you think, oh, well, as an arbitrator, you've been quite sort of maybe protective or proud of your reasoning. But what the ICC, I think, are there to point out is when it's not necessarily obvious to a reader who might be reading it on enforcement, a judge on enforcement. So you have everything, all the evidence. I think that all the Secretariat have are quite more limited documents, but just that different perspective of a group of people who are just reading your award and just focusing on whether it's enforceable and whether the reasoning is sound enough for enforcement, I found tremendously valuable. The other thing that the Secretariat is very useful on is when you make procedural mistakes. So in this one, Jafar was very keen to close the proceedings, and the Secretariat will nudge you to close proceedings. But here, he arguably did it too soon. And when you make such a sort of procedural mistake, as Reilly said, there isn't actually any reason why, if you have made that mistake, you can go back on it and say, well, actually, I need some submissions. So this is a caricature and caricaturely bad, but there are small things that, you know, you do make mistakes on, especially when you're a sole arbitrator and you don't have two wingmen. It's nice to have, or wingwomen, it's nice actually to have the Secretariat there covering your back on enforcement.
Thank you very much for that, Krista. And we'll move now to some of the really interesting questions that we've had in our Q&A chat box. So starting with the first question from Kate, do arbitrators usually accept the comments that are made by the court?
I guess that's for me, since I'm the one that sees after they receive the court's comments. I would say it varies, and we also, the tone of our comments also varies. So, you know, it's quite subtle language. When we invite the arbitral tribunal to consider something, it might just be a stylistic or organizational point that we think might improve just the organizational or overall quality of the award, but doesn't pose a threat to enforcement from our perspective. And those, if they don't take into consideration, we understand and probably are not going to push back against it. I would say in general, they are well received. And the ones that we really, when we say that a sole arbitrator should do something or tribunal could include this, even though it's quite subtle difference, these are things that we do find that they typically take on. And if not, it's a discussion. So if there's a point that the tribunal thinks is sufficient as it is and our comment is unnecessary, then, and usually they will often say that in response to the email, they might list out the comments and say, we're satisfied with the reasoning as it is. And sometimes that explanation is enough. Sometimes they'll say because of this, and we'll ask, well, that's actually quite helpful. Maybe just add that sentence and that would be sufficient for our purposes. So it's a conversation that we're in terms of the points that we really do feel like they need to be taken on and that the approval was contingent on, or more formalistic style points that a tribunal may wish to take into consideration or not.
Thanks, Colleen. And another question that's come up is how does the Secretariat or the court allocate sessions involving the scrutiny of awards among its members? And are the parties able to know who the court members are who are allocated to the review? And is there a basis for challenging them? Maybe Colleen, you want to take that one as well?
Sure. Well, we have our court session coordinator, Chloe Morton, who is actually responsible for all of the behind the scenes of that. And I think that from my understanding, it's court members sign up for the particular sessions, and depending on their availability or whether or not reports are required, but I think the court members might actually be in a better position to know how they are selected for the particular court sessions.
I mean, I can perhaps add on that. I mean, obviously, first thing is we all every month get a list of the new registered cases, and we have to indicate if there's any conflict that we have with them. That's an online process. So if there's a case where you've indicated that you have a conflict with the party, you won't be put into that position at all. Then you sign up for particular sessions when you're available, and there are often multiple sessions per day, and they allocate you according to linguistic abilities, etc., to those sessions. I find that I'm quite often asked to look at English law awards where the Secretariat thinks there's a point that they'd like to have that looked at by the UK court member. So that does happen, and I'm sometimes asked to parachute into a session just to deal with that. Sometimes people are brought in for linguistic reasons, just to a particular award in a session, because when we have these sessions, it's not usually one award, it's usually several, and several other procedural decisions as well, confirming appointments of tribunals and these sorts of things, or extensions of time or whatever. And often you can be brought in where there's a need for a particular linguistic skill, and one of the three members of the committee doesn't have that member then drops out and another member comes in. Or if there's a conflict of some sort, that member drops out and another member drops in. So it's done. I dread to think, I mean, Chloe is a miracle how she pulls the logistics together. She must have the world's greatest sort of spreadsheet to do it. And it must be a nightmare with all of the herding of all the cats that the court members are. But that's certainly my experience, and sorry, on the point about whether parties know who the court members are, absolutely not, and it's obviously highly confidential, and one must never reveal that for obvious reasons. That's my view.
Thank you for that, Krista. And we have another question as well, which is, in the event an award is appealed, does the court monitor this, and does the court reflect on the award as part of the scrutiny process?
We don't necessarily monitor when cases are appealed. We do try to have an idea of when that occurs, but typically we are only made aware if the parties are writing to us for particular documents that they need for enforcement proceedings, or if we see an article published about it. Certainly if there are things that give rise to something on GAR that it seems like a flaw in the scrutiny process, that's something that we're going to take into consideration in terms of moving forward. But in general, we don't have a way to monitor the enforcement or challenges to awards themselves on a regular basis.
Thank you. The next question is, how much scrutiny do you make of the substance of the award? I guess to what extent does the process involve looking at the substance, and can the process sometimes lead to an arbitrator changing their decision on the substance? Don't know if one of the court members wants to take that based on their experience.
Sure, I can take that one. So it's well, first of all, the court's scrutiny is not meant to influence the arbitrator's decisions. It's the award is their product, and the scrutiny process is not there to impose different decisions. So it does not go to the substance. That said, and also we don't have access to all the evidence, the party submissions, so we don't have a complete picture of what has been argued, what the facts are, the evidence, etc., in order to make any comments, any comments on the substance. But in reviewing an award, and I think it was mentioned by Krista earlier, by someone who knows nothing about the case, but sees the terms of reference in a draft award, we do look at, we do want to ensure that the decision makes sense, that the things that the sole arbitrator or the tribunal was asked to decide on, they have decided on, which is why we want to see the list of issues to be determined, the relief sought by the parties, even the most updated one. And we do, it's a kind of a logic and common sense check to ensure that everything has been addressed. And in this particular session, in the mock award that we saw today, obviously the example with the cause of delay being COVID, which does not seem to have been played by the parties, is an obvious point that it goes to the substance, but but it has to make sense. So what we do when these things come up and we do not, it's not obvious whether indeed the sole arbitrator or the tribunal has taken the right decision, we will, the idea is to draw their attention to these points and let them decide which is the best way to address those points. So we won't tell them you should change your decision to decide this, but by highlighting a point that we think it's problematic or raises a question, they get to think, rework, and this may indeed lead to a different decision. It does happen sometimes. So yeah, I hope I've answered the question. I don't know if Louise and Christopher, you want to add something on this?
Yeah, I think, Marilee, I think I think the takeaway for people really is exactly as you've said, that it's not for the court to second guess the arbitrator's decision. That's absolutely within the arbitrator's discretion. That's their liberty of decision as it's referred to in Article 34 of the rules. But I think that by going through the scrutiny process, the whole purpose of which is to procedurally safeguard the award, so to try to mitigate any risk of the award either being set aside at the seat of arbitration or being declared unenforceable in another location. And I think you're absolutely right, Marilee, that whether at the Secretariat stage or the court stage, the court members read something that gives them pause or concern. So it may be just that an item was actually discussed between the parties and the arbitrator, but it's not referenced in the award. So it looks like an issue may not have been considered. So by drawing that to the arbitrator's attention, they have an opportunity to complete the award. And it may be that by applying a rigor to the award, it may be that by the arbitrator in turn, by having to apply a more rigorous analysis to their award, by putting out maybe more detailed reasons or referring, as one of the examples here, referring to Section 60 of the English Arbitration Act, that may result in a different decision on that point.
Yeah, I mean, it's also, in my experience, on these committees, we are quite careful not to get into sort of debating the legal merits of the determination. Everyone's rather careful about that. I suppose the Section 60 point is quite a nice one, because it's a point which is very important, because it is in the Arbitration Act, and it's a mandatory one, I think. So it would be one that the Secretariat would draw to the attention. But because we don't know what has been argued between the parties, we can't go around saying, have you considered ABC case from the Court of Appeal in 1994? And perhaps the arbitrator should take that into account. I mean, there might be circumstances where there's an extremely well-known Supreme Court case which has changed the law or a statute or something, which one might draw to the attention. But generally, we're trying to ensure that we can understand how you go from the parties' arguments through the reasoning process to the answer. That's in a real nutshell what the purpose of the process is, and I think it's extremely helpful to the extent it does that.
Thank you very much, Marilee, Louise and Krista. And what probably follows nicely on from that answer is, does the award come back to the court to check whether the award is amended based on the court's comments?
So in this case, when an award is not approved, as we discussed at the end, a revised award would go back actually to the same committee members, ideally, so that they can see if their comments have been implemented, because they're in the best position, having reviewed the first award. In general, if an award is approved subject to comments, it comes back to the case management team, and the counsel in charge of that team will do post scrutiny, and will look at whether or not the arbitral tribunal has incorporated comments from the court and the checklist items. And again, sometimes this will require a phone call with the arbitral tribunal if there's a lack of clarity, if they've implemented something or if they haven't to an extent that we think they really should have. But in general, and that's something that might be brought up even to the Office of the Secretary General level if the counsel in charge isn't quite sure if it's something that's worth pushing back on. So it doesn't go to the court if it's been approved. And that's what the risk is in terms of discussing whether or not they think that the tribunal will fully take on the comments, because they won't see it again.
And how long does the process of scrutiny generally take? Does it vary from case to case? Is it possible for the court to expedite it where that is necessary? Colleen?
Yes, so it is possible to expedite it in particular circumstances. This is something that if we are informed of a situation that requires being expedited, we can do that. In general, as I mentioned at the beginning, the EPP case awards are scrutinized within 2 to 3 weeks of receipt, and they are sent to one arbitral tribunal member. That's done ad hoc, so it's by email, which is why it can be done more quickly, because every other case will, there, as Reilly mentioned, there's 1 week between when the Secretariat submits the agenda and the matter is reviewed at court. And so for regular awards that go to regular sessions, that's 3 to 4 weeks from the receipt of the draft award. And for special committees, it's 4 to 5 weeks. So it is quite a strict timeline that we abide by when scrutinizing awards, because in the same way that we will reduce an arbitral tribunal's fees for being late in the submission of a draft award, we will reduce our own fees for administrative expenses if we haven't finished the scrutiny process within those timelines.
If I may add just one point on what Colleen said, that when the whole process will be completed, obviously it depends on the tribunal's reaction to the comments communicated to the number of comments, and how available is the tribunal to implement them quickly and revise the award quickly. Sometimes this revision can be done within a few days, but sometimes with a 3-member tribunal and with busy arbitrators or with many comments to address and to implement, this can take longer. So the whole period is maybe extended if there's a delay on that side as well.
And thank you very much, Colleen and Reilly, for those comments. We're conscious we have about 2 minutes left, so final question, which might be of interest, is how does one become a member of the ICC court? I don't know if, Colleen, you'd like to take that in the first instance.
I think the court members might be in a better position, given that have gone through that process.
Thanks, Colleen. I'll go first. I'll just speak from the Irish experience. Obviously, in Ireland, we have a split legal profession, so we have barristers and solicitors, and the way we appoint court members is that on a rotating basis, the bar will nominate, a court member, and the Law Society, who regulates solicitors, will appoint the alternate member. And then 3 years later, they flip, so the Law Society gets to appoint the member and the bar gets to appoint the alternate member. So Ireland, we have 1 full member and 1 alternate member on the court. And I suppose in terms of how those people are chosen, they're people who've demonstrated a track record in arbitration, that they have experience either institutional or appearing as counsel or acting as arbitrator. And the Irish legal pool is relatively small. We're a small country, so it's people know each other, and even I think the international bar of arbitration is relatively small. But that's kind of procedure that's how it happens, as you get 1 nomination from the bar, 1 nomination from the Law Society. And in terms of who those people are, as I've said, they're people who tend to have a track record and experience in arbitration.
Okay, thank you very much, Louise. I don't know if Krista or Reilly, you want to touch upon your own experiences.
Sure. So I'm the Greek court member, and so the way the appointment the Greek court members works is a little bit different, but I think it's the most common method, if I'm not mistaken, in that the ICC has national committees in many countries around the world, and so the ICC court member, one ICC court member, is proposed by the local national committee. So that will be the Greek National Committee. Will know, as Louise explained for Ireland, will know the arbitration practitioners that have the profile that would make them a good proposal for appointment. So the National Committee will make that proposal, and then that person will be appointed officially by, I think, the organ is the ICC World Council within the ICC, and the alternate court member, because there are 2 court members per country, is actually proposed for appointment by the president of the ICC court. So it's a little bit of a different process. And again, the criteria are the same as Louise mentioned. So people who have demonstrated their experience as arbitrator, as counsel, and who are considered to be, good fit for appointment as an ICC court member. I should mention also that the term of the appointment is 3 years that can be renewed only once. So we can only do a maximum of 6 years, and then as ICC court members, and then the court members are renewed at the end of that maximum period of 6 years.
I would just add one thing very briefly, because I know we're almost out of time. It's been I've been a member of the court now for just over a year in my first term, and it is a remarkable thing because all these people are giving, it's a huge time commitment, and all these court members give a huge amount of time, and it is unpaid time to scrutinizing these awards and being part of these committees. So it really is an incredible thing that you get all these top level practitioners who devote all this time to making the system work and providing that incredible added value that the scrutiny process added. So I think that's just worth people bearing in mind.
Thank you very much, Christopher, and everyone for devoting further time to help demystify the process for all of us today. That's really much appreciated. So let me just hand back now to Natalie, who will be closing today's session. But thank you so much to all of our wonderful speakers.
I'll keep this short and sweet. Yes, just to echo that from Sam and Sonia, thank you ever so much for taking out your time to do this for us. I've certainly found it very insightful, and I'm sure the rest of our audience have as well. And it, I think, goes to show the strength of the ICC scrutiny process and just why they make the effectiveness of the awards and strength of the awards are known for what they're known for. So thank you. If we are really wanting to get your feedback from the session so that we can make sure we produce similar sessions in the future that are relevant for you, if you can please fill out the online feedback form that is going to be in the chat. It's a short survey monkey, it won't take long. If you can answer that would be fantastic. And for those that are planning on attending tomorrow in person, we have a fantastic lineup of speakers. Lord Norberger is going to be making a fantastic speech. We have GC in-house counsel, and we have a fireside chat between our president, Claudia Solomon, and Lord Billamoria, who is founder of Cobra Beer. So we have some really great sessions tomorrow, so please do get there on time. I know there are still train strikes that might be happening and have an effect on tomorrow, but if you could get there for 8:30 for a 9 o'clock start, that would be fantastic. So once again, thank you ever so much, and we'll see you hopefully all tomorrow. Thank you, Sam. Thank you, Sonia. Thanks, everyone. Bye.